Welcome to Stolen, the world's greatest eminent domain podcast. Legally, the government has the power to take your property, but most people don't know what to do when it actually happens. If you don't respond correctly, you could walk away with far less than you're owed. And when that happens, in effect, the government steals your property. Our mission is simple: protect property owners, make sure they get the compensation they deserve. The government will steal your property, but only if you let them. Hey, I'm Chad Brown. Welcome to Stolen, the world's greatest eminent domain podcast. We are here again today talking about eminent domain issues. I'm so excited. This is part 2 of our introduction to commercial eminent domain cases. We are running with the big dogs. Speaking of big dogs, Caleb Wheeler's here with me.
How are you, Chad?
I'm doing great. He's my partner in crime. He's very excited. If you haven't seen the last episode, check it out. We compared commercial real estate to running with big dogs, and Caleb is an avid hunter.
Yes, I am, and deer season came in just like I think a week ago.
Really?
In North Carolina,
Yeah.
So bow season though. So yeah, we're excited. So the rut's not quite here, but it's coming. I'm gonna show it now. Okay. All right.
I mean, regardless, we're here running with the big dogs, talking about commercial real estate and commercial eminent domain cases. And so today, what we're going to do is check out part 1, where we go through an introduction to commercial eminent domain. We talk about what's the difference between commercial and residential case. We go through and we really break down the similarities to residential cases, which I think is really important for people. Right. And we start to break out the differences. So today, what we're going to do is we're going to build on that, and we're going to do very SEO catchy, social media trendy top 10 issues in commercial eminent domain cases. Briefly, just to recap, a commercial eminent domain case is one typically deal with an income producing property. It could be a store, it could be a multi-unit apartment complex. So basically what you're doing is looking at income producing properties. It could be a little more nuanced than that, but generally that's the difference. So we're looking at income producing properties, and today we're hitting the top 10 issues. And these are issues that you have to consider and work through to properly help someone in a commercial case. So let's hit with one, our favorite, HBU, highest and best use. How's that issue come up?
Again, yeah, and this is a prior episode. We've already done a whole episode on highest and best use, but generally speaking, it's just it's the legal possible uses of a property that are maximally productive and financially feasible to that specific property. So we look at the highest possible use that is going to maximally produce income or be maximally productive for that property. And so when it comes to a commercial case, man, this gets really, really popular in a commercial case, because now we're looking at potentially what is a property that's currently being used as a single family residential home. And then because of the zoning or because of the nature of the properties surrounding this home, that home could be potentially valued as a commercial building.
So like a mixed use scenario.
So now we have a commercial use for a currently used home, which can maximally produce profit for that property. So honestly, owners love it when we're able to apply highest and best use in these commercial cases.
But even in a straight commercial case where it's being used commercially in one capacity. Right. So think about the old car wash, the little pull it and you get your thing out yourself, and it's sitting there in the middle of town. And you're like, why in the world is this car wash still there? Other than, according to some people on the internet, those are great businesses, but we'll leave the debate of that to the internet. But that car wash best use might actually be a commercial building.
Like a real space for commercial offices.
Yeah.
Yeah. I mean, it could be that. It could be what. Okay. I feel like I'm not trying to get too Disney here, but it depends on your imagination. Right. It depends on your imagination. Like, yeah. So you have to use your imagination, and
so let's just go down that road. So let's just
let's
think about Walt Disney.
All right.
Walt Disney built Disneyland in Orlando on a swamp.
He did.
Now, completely off the fly. This is completely not fair to you, but
it's okay.
So if the government had taken Walt's land back in the
man,
could you have argued that highest and best use was the greatest place on earth?
It's a magical kingdom.
Could you? I mean, I think that was got crushed, right?
No, not necessarily. I mean, if it's already encouraged, okay. So
it was a swamp.
It was a swamp, but if so, based on my understanding of the hypothetical was that it was already built.
I'm saying if
Walt is the advice of the property.
If the state of Florida came in to buy the swamp from Walt, could he have argued Disneyland?
No.
You don't think so?
I know he could.
Why?
Because there's only one magical kingdom, and you have to have evidence to show what could be the highest and best use. And if nothing like that ever exists, if it's the only, it's the most magical place on earth. If it was the only magical place on earth, I mean, they could have looked at Disneyland in California.
Which was built first?
Disneyland in California.
Are you sure?
I'm pretty sure.
Heidi. She said Heidi Max, our producer. She's awesome. I'm looking down at the camera here. Like I need to look at the camera. How you can check out and see which came first. We'll give that back to you.
Yeah. So, but potentially, but still, that's a stretch regardless. So maybe not. But however, I will say that they probably could have got the highest best use for a development. Subdivision. But sure, that exists.
The point is highest and best use of the property in commercial cases, big issue. We're never going to get through the whole 10. We hear this right. Okay, so let's talk about what it's actually. I don't think HBU. Highest best use, show me the money.
Yeah.
That's probably the one. 2 is business impact.
Yeah.
So 2 real quick issues I think people need to understand in the commercial case. You have the functionality impact, that is, can you still operate your business in the way it's being operated? And then you have sort of a second related issue of the income impact. Commercial cases, I mean, the business impact globally, I mean, it's a huge issue.
No, absolutely. When it comes to site functionality, essentially. And so we're not necessarily talking about highest and best use with that. What we're talking about is damages.
Right.
It's really a damages question, because if your highest and best use is the current use as a commercial property, let's say you have a strip mall there, that's the highest and best use. But if you lose parking, or if they're taking part of your buildings, now you're losing income and you're losing access that's directly related to those buildings.
Yeah, you can't functionally have the grocery store if you only have 12 parking spaces.
No, you cannot. Absolutely not. Well, everybody's Instacarting, but yeah, that's a different issue.
Uber Eats.
Yes.
Do they always deliver groceries?
Absolutely.
Do they?
Yeah.
We do our grocery shopping the old-fashioned way.
The old-fashioned way. You got to get out of the house somewhere.
We push them.
Yeah. We need an excuse to get out of the office.
Yeah. So parking, visibility, goodwill, all those things are going to, there's sort of a whole umbrella of business impact that's going to have to be evaluated in the first place.
Absolutely.
Okay. So let's beautiful segue. I love it when it comes together. Yeah. So our great Food Lion, the town, let's just use Mooresville here. Let's say the town of Mooresville requires, I don't know what they actually require in the zoning. I'm just going to make up a number. Let's say they require 146 parking spaces for a grocery store.
Okay.
And now we have 46 parking spaces left. Now we're into issues with zoning and nonconformity, correct?
So your hypothetical is assuming 100 parking spots being lost.
Yeah.
That's definitely going to trigger a zoning issue.
Yeah.
I mean, I don't even have to look at the rules. I can tell you that.
So in a commercial case, because not everywhere, there's some counties. What's North Carolina on?
Oh, Craven.
Is it Craven?
I think it's Craven. No, I think I'm pretty sure it's Craven County, out in the mountains.
What's down?
Pretty sure.
And I took North Carolina, like it was in 8th grade, 40 years, I think 40 years ago.
Oh, yeah.
So the point is that in most counties have zoning.
Most counties have zoning.
Yeah.
So regardless,
so you're in a commercial. If you're in a commercial property, you have commercial zoning, and you have zoning sensitivity. So if the zoning changes, or you can't meet the zoning requirements, and you end up in sort of non-conforming status, then that can have a huge impact. But with a residential case, you're not typically looking at. I mean, could look at mixed use at rise to mixed use, but with the business, you're looking at zoning. Generally, it can be impacted.
Yeah. So the two issues with that. So first off, let's say you're currently in zoning compliance. The zoning has not changed, but because of the state action, you're now outside of zoning as a direct result of the eminent domain action. Right. So with that being said, that's damages. Right. Then there's also the issue of zoning change. Right. And then the eminent domain happens. So now then the active eminent domain happens, which then puts you out of compliance with, which basically you're grandfathered in after the zoning change. Then the eminent domain action occurs, which puts you now you're no longer grandfathered in. So now you're out of compliance again.
So zoning sensitivity is a real thing.
Oh, it's an absolute real thing with these commercial, all eminent domain cases, really.
Yeah. Number 4.
Okay.
Did you ever watch David Letterman? So you old enough?
I mean, I know who he is.
He's at least at the top 10 list.
I always thought he looked like the most nerdy dude on late night TV.
From the guy who looks like Happy Kangaroo.
I don't know.
All right. Partial takings and remainder damages.
Okay. So partial takings, issues that go with that. I mean, man, Chad,
you don't know who Happy Kangaroo is.
I had no idea who Happy Kangaroo is. I was like, okay. So anyways, that being said, partial takings and remainder damages. So again, the measure of damages is what is the value of the commercial property before the taking? Again, looking through the lens of highest and best use, and then what is it after the taking? Plus severance damages, which could be, they're taking an improvement, a tree, parking, access, whatever. All these things they're added together to come up with what damages are with these partial takings. Again, with a full taking, just as a reminder to our audience, a full taking is going to be valued, the entire property together is going to be valued.
Right. But again, but often in commercial cases, you're going to have partial takings and remainder damages. Let's go to 5. We're going to get through these. We don't get through. Okay. Lease issues.
Lease issues. So, I have a lot of friends in this space. Literally, all they do in eminent domain is usually just lease, commercial lease, interest, litigation in these eminent domain cases.
Right.
So, I mean, that's a whole thing in itself. But, however,
we do cases sometimes like we'll get a referred case for like the development is being represented by like some big law firm that they can't represent. They have conflict of interest. They can't represent the tenants. So they'll call us up and say, hey, can you represent the tenants in these cases?
Absolutely. So again, leases, the main thing to take away from this for our audience is the lease is going to control the interest of eminent domain in these cases. So who gets what, essentially? There's usually going to be an allocation clause or something with regards to eminent domain in these lease contracts. So that's this, again, another precautionary tale for all those who are getting lease contracts for commercial space. You need to have an attorney representation help you draft these lease contracts to ensure your interests are protected in the case of eminent domain. Now, that being said, typically, if there is no lease contract, which there should be, the owner gets the damage. They get the settlement or the award.
Right.
Okay. It's not going to be the tenant.
But the point is in the commercial case, because of the nature of commercial properties, you're often going to have lease issues, and then you have multiple defendants frequently, and then you have issues with allocation of the settlement. Okay.
Yeah.
Signage, billboard type issues.
Yeah. So signage issues. So a couple things with that, just about one of the unique aspects of the law in some states, like if the government does something to inhibit the sign's visibility, like they plant a tree, that's not compensable. But if they're doing something to take the sign down or to interfere with your ability to use that sign, put your message on it, whatever, then that's compensable.
Right.
So,
but signs are a big deal in the commercial space.
How else do people know where you are? So,
internet. It's called Google.
Without Google,
Google.
But you have to have. But
then how do they find you when they're?
But if you're at Suite D in a 5 unit place, it's like, well, how do you? Is this? And all the buildings look the same because the same development company built everything.
And the DOT took your frontage sign that said you were in 5C, and now nobody knows.
There you go. So now you have to have. That's where expert testing. I get with every one of these points you're bringing up. You got to have experts. You got to have appraisers. You got to have. There might even be I don't know this for a fact. There might even be a sign expert out there. Who knows? There certainly is more
sign experts.
Yeah. Okay. So
they're called signologists.
Heidi, don't check that. Don't check that. So when it comes to
you're the one talking about Tom Cruise.
I know.
The last episode. Is that 2 episodes?
Jerry Maguire, yes, 2 episodes ago. Y'all out show me the money. So when it comes to
He's a sinologist.
So I give up. Whatever. Okay. So no, it's
property access. Property 7. Property access, driveways, parking changes.
Okay. Now we have a balancing. The state's generally going to look at this. Well, not the state. The courts are generally going to look at this with a balancing test. So essentially, how much of your access is being affected, and is it such that it's actually going to inhibit your property's value? That's the real question when it comes to access. That's the real question. Is it just an incidental, minor inconvenience, or is it a major inconvenience such that people don't even come to they don't even give you any patronage anymore to your commercial building? Are you losing tenants as a result of it, and because they can't access it with their equipment? Does the commercial business that you rely on does it rely on tractor trailers? And is the access being inhibited such that now you can't even access it with tractor trailers? These are questions that have to be asked and assessed when it comes to these access issues. And again, expert witnesses.
And now you've started at the road and looking at, okay, did you impact my ability to get from the road to the parking lot? And then did you affect the parking lot when I'm there? Do you impact what I can do in the parking lot?
Like, can I turn around?
Yeah. Related issue, TCEs, temporary construction easements, PUEs, permanent utility easements. We did a whole episode on easements. Check it out. If you don't know what the heck we're talking about, go find those episodes. But directly with the property access, especially in North Carolina, I mean, you have all these cases pending in the court of appeals currently on these PUE issues where the DOT got a little greedy with how big a PUE they were going to take, and Dave Henson, those guys, and shout out to Dave, good guy.
Yeah.
But the reality is the PUEs were so broadly drawn that the courts have been finding that they've basically eliminated access to the businesses.
Oh yeah.
So just to understand, there's a relationship there between the impact. They don't have to just take a fee simple. It's not just the property they take. It's the limitations on what you might be able to do on your property through easements that matter as well.
Oh, I mean, and the easement issue is when I read the language of these easements, and I see how broad and encompassing they are. It's not defined very well as to what they're going to do with these easements, so they get really broad. And I feel like it's sneaky. I don't care if it's commercial or residential; it doesn't matter. But it feels sneaky because it's almost like they're taking more than what we traditionally think of an easement to be.
Yeah.
Traditionally, people think of easements. They think of, I'm a road going through my property to my neighbor's house, and so they can access their property. No big deal, right? But sometimes in in the context of these easements, you have to realize with a construction easement, we don't know really how long they're going to last.
Yeah.
They're very wary of putting a time limit on them because, and for some conceivably good reason, right? Because funding is an issue.
Right.
These projects are being funded by the state governments, and sometimes funding gets held up. There's a natural disaster, or there's something called COVID. Whatever the case may be, sometimes the funding on these projects can be a little bit tough to get to, and so these projects get held up. However, sometimes it's just outright lack of planning,
right,
and inefficiency, because the government's always usually pretty efficient. What? So what I'm saying is this: the government has to sometimes they're not very efficient, so these projects can get really just carried out over a course of many years, and you have to be compensated for that. Commercial property owners have to be compensated for the amount of time the TCE is going to last.
Temporary means 7 years.
Temporary can mean 7 years.
You're what years? You never know.
Yeah.
All right. We're never going to get to the top 5. We don't get through the top 10.
Okay.
Issue 9, relocation cost.
Relocation assistance is going to be, so it's a federal relocation assistance, and there's state relocation assistance, depending on what type of project, who's funding it. Most states in the union have passed relocation assistance statutes.
So if your business gets completely taken, you have to move, or you're a leaseholder and you have to move, they're going to help pay.
Yes.
Finally, in the top 10, drum roll, special property uses.
Special property uses. when I think of special property uses, I'm thinking obviously highest and best use, and I'm immediately going to valuation issues.
It's talking about unique properties, unique scenarios, unique locations, unique issues, unique treatment.
Yeah. Right.
All right. That's the top 10.
Yeah.
5. I'm going to give them. I'm just going to bust.
All right, go to
this. I'm just going to. Yeah, you'll never get this.
long-winded.
Top 5 practice pointers. And so when you have a commercial case, you need to understand the issues and you got to find some. But we have a very sort of simple 5-step process that we go through in a commercial case. One, you got to build a team. You got to build your team. That's going to be, if you're the property owner, that's one, getting good counsel to help you. It's bringing in the right experts, the right appraisers, finding the cyanologist that you need.
The hydrologist
up there in California for purple suits. Once you build your team, you got to build your case. What 2 is you got to build the case. Remember, especially the highest and best use comes in these a lot. It's not about speculation. It's about putting together the right team that can build the right case, that part 3, that you're going to prove with the right evidence. So, if you're in an income capitalization, you need to understand things like the P&L for the business. You need to understand things like sales. You need to understand things like how traffic counts impact valuation. And then finding real evidence to support that. It's not just, well, it can't be anecdotal. Like, there has to be real evidence. So you're going to build your team, you're going to build your case, you're going to get the evidence to make that case stick, and then you're going to make your argument. You gotta argue. I don't know why I keep thinking about Jerry Maguire.
Oh no, man.
He's like, show me the money. Like, you got to make the argument. You have the best team and you build the case, but you're not willing to go to the mat and fight for your client. You got to make the argument. But then the one people forget is the final thing you got to preserve the business. Yeah. At the end of the day, most business owners don't want the last day of their business to be the day that the DOT took their property. Most business owners want to go out on their own terms. And so doing things to preserve the business moving forward, so that even if there are some damages, if there are sort of difficulties that come about because of the condemnation action in the eminent case, you're able to still preserve that business and help your client move forward. So that's it, Caleb. We're out of time. By the way, for those of you who are curious and didn't know, Disneyland did come first. Shout out to my girl Heidi, top producer. Caleb got one right. Maybe he's a big dog after all. All right. Till next time. Stolen, world's greatest eminent domain podcast. Please subscribe, follow us, check out our older episodes. Golly, if you get an eminent domain case, get some help. Take care.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.